Hi, I'm Jamie Johnson of the Johnson Law Firm, where we do estate planning and probate, and we do it well. Today I'd like to talk to you about what is an irrevocable trust. Now, you hear the term trust a lot. In fact, there are two types of trust. There's a revocable trust, which is the most common trust used in estate planning. A revocable trust allows the creator of the trust to revoke or amend or tear up the trust at any time during their lifetime. So that's why we typically use revocable trust, and we don't even use the term revocable typically, we just say a trust, because with a revocable trust, it keeps control with the person that's creating the trust. Typically, they're the creator, they're the original trustee, they're the original beneficiary, and only upon their passing or incapacity do they lose control of those assets or hand the trusteeship over to somebody else. However, in an irrevocable trust, one of the downfalls of a revocable trust is that because the creator of the trust still maintains control of the trust, it's still part of their estate and it's considered to be their assets. It's still taxable to them. It's still accessible by their creditors. The other type of trust is an irrevocable trust. With an irrevocable trust, the creator of the trust is actually giving up control of the trust. They're saying that these are the rules, they are set in stone, and the trust cannot be changed without approval of the beneficiaries and the court. Now, most individuals don't like to give up control of their assets. That's why irrevocable trusts are not commonly used, especially amongst younger families or middle-aged families. Where irrevocable trusts are most commonly used is when you're talking about our elderly clients who are looking to avoid issues with nursing home and Medicaid. When we're dealing with elder law and dealing with our older clients in terms of irrevocable trust, the reason why we want to use that irrevocable trust is it starts the clock on the 5-year look-back window for Medicaid. When an individual goes into a nursing home, they are not Medicaid eligible to pay for the nursing home until their assets have been spent down to the amount of $2,000. So if dad has passed and mom is possibly looking at going into a nursing home, when the house is sold to liquidate it to make sure she has enough assets to be able to pay for the nursing home, which in this area in Northern Virginia, typically a nursing home will run anywhere from $6,000 to $10,000 a month. Now that can very quickly drain the estate that a husband and wife had built up over a lifetime. A couple of years of being in a nursing home, that will spend every last dollar they have and leave nothing to give to the children. There's nothing for them to pass along. Most of my older couples are really concerned about that. They want to make sure that they leave a legacy for their children or for their grandchildren. However, they also want to make sure that they're not shoved in a bottom feeder nursing home. They want to make sure they receive good quality care in their last remaining years. A way that we can use an irrevocable trust to protect them is we take their assets, we put in an irrevocable trust, and we name a non-family member as the trustee. Now this is important because the IRS looks at it and says you can't name your children as the trustee because the children are just going to do what the parent wants them to do with the asset. So the parent is de facto still in charge of the asset. So we need to make sure that we're naming a trustee who is not a family member. It can't be what we call a straw man. It has to be an actual independent trustee. Now that trustee is bound by the trust, so they can still use it to benefit the creator of the trust. However, the creator of the trust cannot maintain any strings of control over the trust. Otherwise, it violates the IRS rules. Where this can be a benefit is you place your assets into an irrevocable trust and you make it 5 years before you need to go into a nursing home. Those assets in that trust are now protected from the nursing home and protected from Medicaid making a claim on the estate. This is a wonderful thing because now Medicaid can be used as the primary source of payment for the nursing home, and the assets in the trust can be used to supplement that. So it can be used to make sure that your last years in the nursing home are optimum quality, that your assets aren't spent all the way down to where you can't afford nice things like to do a trip to the movies with other members of the nursing home, to have your hair done or nails done. Those little niceties that really make a difference when you're in that community of the nursing home. We want to make sure that you have access to those assets, and as most of my clients say, they don't want to be a burden to their children. With our irrevocable trust, we can accomplish this. Usually we look to do this in your early 60s. If someone has a family history of mental illness or things of Parkinson's and Alzheimer's, if there's a possibility that you might be looking at an extended period of time in-home care, nursing care, then irrevocable trust would be something you really should look into. If you'd like to discuss this further, please reach out to the Johnson Law Firm. We'll be happy to answer them for you.